Hi, welcome. I'm Eric Rodebois. This is 5 Minutes with Eric, EPGD Attorneys at Law PA, also known as EPGD Business Law, also known as EPGD Law. And so what we're going to talk about today is the Florida Civil Theft Statute. But first I'm going to give a little primer on two important things, the American rule and the all-important attorney's fee provision. So the American rule says that each party must bear their own costs. And what this really means is that when people go into litigation against each other, you pay for your guy, I pay for my guy. Now, you might ask yourself, well, that's not fair. What if somebody wrongfully brings a lawsuit against somebody else? And so the answer is that there are rules and, of course, our professional ethics to prevent lawyers from actually engaging in that type of frivolous behavior, and judges will sanction both parties and lawyers for frivolous lawsuits. Now, unfortunately, that is probably not enforced often enough, but however, just go back to the basic rule. Each party must bear their own costs, unless there's an attorney's fee provision in a contract or there's an attorney's fee provision in a statute. So in a contract, and this applies nationwide, state by state, I know we're talking about the Florida Civil Theft Statute, the contract rule basically says that when you get into a fight with someone, if you have a signed agreement, your lawyer, like me, might say, hey, let me see a copy of that agreement. Now, it's an employment contract, terms and conditions for selling products, joint venture agreement, a partnership agreement, a intellectual property licensing agreement, a landlord-tenant lease, whatever it is. You're in a fight, I say let me see the contract, I flip to the back, it's the boilerplate, most important part a lot of the times, and what I'm looking for, very magic little words, prevailing party shall be entitled to reimbursement of their fees and costs, or maybe their reasonable fees and costs. Voila. That means that suing someone for $1,000 or $10,000 or $100,000 is not prohibitively expensive. And you say $100,000, yes. Fees in a lawsuit can easily go into the millions of dollars depending on how much we're going to invest in that fight. So if we're suing for $100 million, $1 million of attorney's fees is perfectly fine. But if we're suing for $1,000, you're like, come on, that's ridiculous. We're not going to get to $100,000 of attorney's fees. But my point is that if I see that magic language in the contract, now all of a sudden there's at least an incentive to talk about it. Quick practitioner note, if I know I have a client who's kind of a scumbag, a lot of times when I'm drafting the contract, this is in the beginning, the transactional side, I will take the attorney's fee provision out of the contract because I know that more likely than not, my guy's going to end up in a fight with someone and might be on the losing side of that fight. Now, on the other hand, if I have a good client, which hopefully most of my clients are, then I make damn sure that there's an attorney's fee provision in the contract because my guy's good, which means if we're in a fight, I know that we're going to win and we're going to get our fees back. Okay, so what's the civil theft statute? Well, it's one of many statutes in Florida which if we can sue under, we can get attorney's fees. So let's go to the situation where you have maybe an oral, like handshake contract, nothing in writing, and one guy screws the other guy. You come to me and I'm like, well, I'm really sorry, there's no attorney's fees because you don't have a contract. But wait, let's see if we can get it under statute. So the civil theft statute is basically when somebody steals from somebody else in a commercial transaction. So here's a great one. I'm going to sell you this pencil, give me $10,000. The guy give me $10,000 and I never give him the pencil. I just stole $10,000 from him. That's what we call theft. Now, it might be under the guise of selling a product, and it might even be with a written contract. Well, here's the beautiful thing. If you go to the statute, and for all of you out there who are taking notes, it's Florida Statute 772.11. And under this statute, we can send a very specific letter that has language that needs to be included from the statute. And the letter says, pay the $10,000 to my client who was, or at least, who was trying to buy the pencil within the next 30 days. And if you do, we're cool. If we're not just going to sue you for breach of our oral contract, or maybe even our other written agreement. We're going to sue you for breach of Florida Statute 772.11, which includes, as an incentive for you to do what's right, triple damages, so my $10,000 just became $30,000, plus attorney's fees and costs. So now my client who says, well, I'm not really sure if I want to pay a $5,000 retainer to a litigation team to sue for $10,000, right? I'm going to pay $5,000 more for $10,000, but I'm like, but don't worry about it, because now we're suing for $30,000, and you're going to get that $5,000 plus whatever else it takes paid back. So the point of the story is, for all of you out in EPGD land, is attorney's fee provisions are very important. It's what protects us from those frivolous lawsuits, right? Because the guy's not going to bring a frivolous lawsuit if he knows that there's going to be attorney's fees on the backside. And it's going to protect you because we can find these statutes, and maybe, especially with the civil theft statute, have a great tool in your tool belt to get you paid. So this is Eric Rodebois coming at you from EPGD land. Thank you so much. I'll see you guys next week.